Good, RJ. How are you?
Good. Recognize a lot of names on this webinar this afternoon. Welcome, everybody. We're just going to dive right in. This session is being recorded. My name is RJ Pahura. I'm with Fund Conference. And with the current epidemic, we are doing everything but hosting conferences right now. Imagine that. So that is my not so ill joke today. We do have some doctors on the phone or on the Zoom. So would love to hear from everybody. However, just with the sheer amount of people that we do have on this webinar, I think what we'll do is we'll just open up Q&A a little bit later. So I want to start by just introducing myself, which I already did, RJ Pahura with Fund. Today, we are going to do a thing called Fund EDU, which is something as many of you on this call have even sort of experienced in the last couple weeks. Really, this epidemic is changing minute by minute, day by day. And we sort of have also had an evolution of our business and some additional service offerings, one of which is this Fund EDU. So it's a resource that anybody can use anytime, anywhere, free of charge. And we get the most preferred subject matter experts as it relates to entrepreneurship, investing, in the entire ecosystem. So appreciate you all joining this afternoon. We are going to have at least one of these a day. Tomorrow we have something on contracts and just things as it relates specifically to the epidemic. Today we're going to talk about labor and employment, which is a huge topic right now, as we're seeing with the layoffs and some of the unfortunate events that are currently arising. And on Wednesday, we are actually going to talk about raising capital during this time. So for the entrepreneurs on the phone that are going like, how the hell do we raise capital during this time? We're going to address some of those things in there. We're going to talk through the SBA options and some of the things that state by state and city by city are doing as well. So that is the format. Today we're going to go anywhere from 30 to 45 minutes. I would ask that everybody sort of just please, number one, mute your phone, and two, hold questions till the end. We're aiming to go about 45 minutes. Kathryn from Polsinelli, who I'll just introduce here in a minute, is going to give a very short presentation. Then we're just going to go into some more open format. So without further ado, Kathryn Curry, Polsinelli. I'm going to share my screen with you guys. We currently have what looks like 24 or 25 people on the call right now. I'm going to share my screen and show you guys a couple things really quick, just so you're aware with some of the things that we have coming up this week. So if you go to our homepage here, it's fundconference.com. Scroll down to, excuse me, I'm moving some icons on my desktop here. Scroll down to where it says Fund EDU Online, click Learn More, and you'll see all these sessions that we're going to have on here. This content is being updated like by the minute, guys, as we continue to add more and more of these. And we're trying to make it very close to what we are all personally going through with this pandemic. So again, you'll see the three that I just talked about here. So go ahead and check those out at your convenience. We'd love for you to join us on those. Again, these are recorded, so if you can't make this, feel free to go back and enjoy any of the other conversations as well later. Polsinelli, we've worked with for a long time. They are a national law firm, and I will be taking away and giving it injustice, so I'll let Kathryn do some of the introductions, but I do want to just introduce our presenter today. If you can see my screen, she is a local Chicagoan. I know we have people on the phone from all over the country right now. But cannot say enough great things about Polsinelli. We've used them in every single city that we're in, as well as they're one of our retained firms as well. So Kathryn specializes on employment and labor law, which we're going to talk through today. So without further ado, I will be quiet, hand it to the presenter. Thank you guys again for joining us, and I look forward to a great conversation. Kathryn, good morning, or good afternoon.
All right, am I unmuted? Can you hear me?
You're unmuted.
All right, thank you. Good afternoon, everyone. As RJ mentioned, I am Kathryn Curry with Polsinelli, so I'm in the Labor and Employment Group at Polsinelli, and my practice consists of counseling employers on a variety of employment issues and needs. I also do a little bit of litigation, but mostly my practice is based on the counseling side. So we are very busy right now with everything that's happening in the nation with respect to coronavirus. And it does, as you can imagine, vary state by state. But I'm going to give you sort of a broad overview of some of the issues that I think are important to keep in mind right now. And then I know that we will be touching on some questions as we go through this webinar. So I'm going to share my screen because I just have a few slides that I put together just to kind of help guide through some of the bigger questions that employers are facing right now, and hopefully give you some information that perhaps you haven't had or maybe could use some clarification on. So let me just find my presentation here, which let's see here. Give me 1 second. It's not showing up for me, so 1 second. It just was here a minute ago. There we are. All right, so hopefully you're seeing what I'm seeing with respect to this slideshow. So just to go over quickly here, the recent legislation that was passed, the Families First Coronavirus this one, does it apply to you? It does apply to all employers who have fewer than 500 employees. So it's my understanding everyone on this call, attending this webinar is in that category. What does it provide for? So there is a few different points that I wanted to bring up today on what it provides for. It's a paid sick leave provision. That's 2 weeks or up to 80 hours of paid sick leave at an employee's regular rate of pay where the employee cannot work. So that means cannot work from home either, because that person is subject to a federal or state or local quarantine or isolation order, was advised by a healthcare provider to self-quarantine due to COVID-19 or experiencing COVID-19 symptoms themselves. So that's one aspect of the law. It also provides for 2 weeks or up to 80 hours of paid sick leave at 2/3 pay if that individual cannot work, including cannot work from home, because they're caring for an individual subject to a quarantine order or caring for a child if the child's school or daycare is closed due to coronavirus. So those are two portions of the paid sick leave. That's that first 2 weeks. Now there's also a portion of this law that we're referring to as the FMLA expansion portion. And many of you, if you're not an employer of 50 or more employees, maybe have not paid much attention to the Family Medical Leave Act, but now you will need to for purposes of this new law, because it does apply to any individual employed at least for 30 days before the date of leave. And that individual is now entitled to 12 weeks of job protected leave at 2/3 their regular rate of pay. And this applies for those who are unable to work or telework because they need to care for a child if that child's school or place of care is closed. So those are two important provisions for all employers to note. You do have to post a notice, and that is available now on the Department of Labor's website. So you need to have that ready to go by April 1st. That's when this law goes into effect. And a big question that you all might be asking is, does this really apply to me? Because I've heard there might be an exemption. If you are a small business, you may be exempt from a certain portion of this law. So if you have fewer than 50 employees, you're exempt from providing paid sick leave due to a school or place of care closure where the child care provider is unavailable. And so you're not exempt from the law entirely, and that's something that really was just clarified by the Department of Labor. So we were initially under the impression that if you were an employer with under 50 employees, you could possibly document that you're exempt from the law entirely. But the Department of Labor has now clarified that is not the case. You will still be required to provide some portion of paid leave under certain circumstances. So I can talk about that more if there are questions. Just to keep this moving, I'll go to the next slide here. Furloughs versus layoffs. It's my understanding that a lot of you have asked questions about, you know, how do I decide whether I lay off employees or I choose to furlough employees? And we've gotten a lot of questions about how long a furlough can last. This is really, there is no defined time limit for furloughs. You don't want a furlough to go on for an indefinite period of time or a long period of time. Larger employers, it's more important for larger employers to be cognizant of this, but if you are a small employer with, you know, under 50 or under 100 employees, you have a little bit more flexibility here. But generally speaking, it is up to the employer. There is a reason, I suppose, that you would choose furlough over a layoff, which is the fact that you expect to be bringing these individuals back. You do not want to see your workforce gone. And you expect that things will get better, and therefore you want them to know that you're thinking of this as a temporary solution. If you are going to furlough employees, there's some things you need to keep in mind. You should be telling your furloughed employees that they're prohibited from working during the furlough. They can use PTO and vacation time if they choose. That's a big question that's come up too, because I know I've had employers say, well, does that not affect their ability to get unemployment? And it would potentially for that week or time period that they're using that PTO or vacation time, but it's still an option for employers to give that to their furloughed employees if they wish to do so. You should also let them know that they can apply for unemployment and provide continuation of benefits information. And another issue that's come up quite often is, you know, what if I want this furloughed employee to check emails while they're gone, or, you know, they're still going to be getting emails from our customer base. What do we do? And from a legal perspective, you don't want that at all. You really do need to set up a system where those emails are automatically forwarded to somebody that is not furloughed. That's probably the best practice, because you don't want the situation where a furloughed employee is still working while they're technically not supposed to be working. That can open you up to liability down the road. So there is a more complicated or longer conversation we can have about whether technically they really are working or whether it's de minimis work, just checking an email and forwarding it on to somebody at the company. But overall, the better move on your part is just to indicate they are not able to work, and that includes not able to check emails. There is something else that you should consider with respect to furloughing, and that's just the benefits issue. I am not a benefits attorney, but we certainly advise on these issues with any furlough or reduction in hours. You just really want to check with your provider. Your medical include an hours of service requirement for an employee to maintain eligibility. If an employee is no longer providing any service, that employee may no longer be actively eligible under the plan.
Hey guys, Mary Kathryn, I'm sorry, real quick logistical thing. For some reason, we're having an issue seeing your screen. It's like kind of grayed out in the center. Do you mind just like, you can either send it to me and I can present, or if you want to toggle in between, I don't know, maybe that'll help.
Let's see if I can. So you don't see any presentation at all?
It's kind of grayed out. We can see the slides to the left, but we can't see the main presentation itself.
Let me just send it to you and see if that'll work.
Okay, we'll do that right now.
All right.
Sorry, while I'm pulling that up, you can keep rolling.
Well, I'll have to just give me 1 second and I can get it sent to you.
Thanks everybody for holding tight. This just 1 minute and we'll get this screen share here going.
All right. It should be on its way to you. 1 second here. All right, you should have it, and I can keep going. And then the slides are fairly minimal, so I can keep talking a little bit about this. The other thing, so I think I finished my point on the COBRA issues. You just want to make sure that you're talking with your provider about that if you do decide to furlough any of your workforce. So job sharing and hours reduction is also something that we're seeing a lot happen right now. Shared, these are often called shared work arrangements, and they serve as an alternative to layoffs for employers. And it allows you to divide the available work among a specified group of affected employees. So hourly workers could receive a portion of their unemployment benefits while also working reduced hours. So that's something to think about. One thing that we're not sure of yet, but this may allow you to avoid paying higher unemployment taxes by reducing the number of employees eligible to receive unemployment benefits. There's not been a lot of clarification on whether or how this is going to work for employers with respect to unemployment taxes. There may be changes made in the wake of coronavirus, but as of right now, that still may be an issue for employers to be thinking about. For salary reductions, just a few points you want to keep in mind. You'll need to ensure that any reduction in wages does not go under minimum wage, and a reduction in wages for salaried or exempt employees should be at the start of a new pay period always. Any wage reduction can only be applied to hours following a notice that you're changing the salary or hourly wage for that individual. You don't want to apply this to hours already worked. So moving on, I don't know if you've gotten the slides up yet, RJ, but I'm going to keep going.
Yeah, I don't know if it's a larger presentation or not, but it's not come through yet. So if you just want to roll with it, then I'll open it as soon as I get it.
Sure. Okay. No worries. So another question that we've been getting a lot of is, can I switch my exempt employees to non-exempt and then cut hours so they could receive the difference in unemployment benefits? You, as an employer, have the flexibility to offer hourly employees fewer hours and workdays, but not exempt employees. So under the Fair Labor Standards Act, or FLSA, employers must pay an exempt employee his or her full weekly wage, regardless of how many hours the exempt employee works per week. So that's something to keep in mind. You don't really want to go down that path. Can you reduce an exempt employee's salary? Yes, you can. The U.S. Department of Labor explains that employers are allowed to make a reduction of an exempt employee's salary during a business or economic slowdown. And we're certainly in that realm. If the reduction is not related to quality or quantity of work performed and is not for and is in place for a significant period of time. And that's just referring to the fact that they don't want employers on short-term basis reducing salaries of exempt employees. So good advice in general on this front is to do it across the board, company-wide, or by departments if you can. And keeping in mind, again, with any salary reduction, that you want to notify your employees prior to the pay cut and make sure the pay cut is not discriminatory. So you just want to keep in mind that across the board cuts are safer. Company-wide is best, just so you're not picking out certain employees or groups of employees, and that could be problematic for you down the line. Make sure there's no contract that's providing for a specified salary with that particular employee, and you don't ever want to cut anyone's pay, making it, putting them below minimum wage. So always keep that in mind. So the other thing I wanted to just touch on is the most recent stimulus package passed and signed into law, which is the CARES Act. Now, this is going to probably be covered by some of my colleagues because it has more to do with loans than employment issues. But I just wanted to bring this up because I think it's very relevant to potentially to some of you. Some of my smaller clients are asking questions about this. There is a Paycheck Protection Program in the CARES Act, and it covers payroll for about an 8-week period, and you can cover payroll, health insurance, rent, utilities with these loans, and there's a loan forgiveness component to it. So it's very intriguing to many of our clients who kind of fit in this small business category because the loan forgiveness does apply as long as the number of employees and or salaries are restored or still employed by June 30th of 2020. So there will not be a downward adjustment on the forgiveness of the loan if you keep your workforce in place. Now that's a big question for some employers. They've called us and said, you know, I want to take advantage of this loan program, you know, which the principle of the loans are completely forgiven if I keep my workforce in place, but what if I can't keep my workforce in place or I don't know? So those are just some of the bigger questions to keep in mind on the CARES Act, and certainly you would want to talk to somebody in more detail about it, but it is out there and you should know about it. So generally speaking, these are some of the bigger issues in employment laws, you know, as far as like how to figure out what to do. You know, this is a really unprecedented situation that we're in, and basically what I can advise you to do is, you know, how to stay in line with the legal requirements, but so much of this is a business decision and just how you need and want to move forward with your business to make it work for your company and for what's best for your employees and your team. So with that, I think I will open it up. Those were just some of the bigger topics I wanted to cover. And at this point, I think I can pass it back over to you, RJ, if we want to do questions. I think you're muted, RJ, if you are talking.
That makes sense. We do not, thank you. We do not have a raise hand function on this, unfortunately. So without everybody.
I've got a question.
Yeah.
Yeah, my name's Carl Rauscher. So what's to prevent a company who does not have any income issues and does not have any, loss of employee issues say, hey, I want to take a loan out. And because it's going to be, low interest and maybe don't have to pay it back. I mean, some people, hey, wow, I got to let my employees go and then they bring it back. Or but what happens with companies? They have to demonstrate in any way that they're in a situation that they have stress in any quantitative way.
That's a great question. And I was looking into that for one of my clients. Again, I will defer most of these questions to our loan enforcement attorneys who are really covering this law in granular detail, because there are details I am just, I have not read the law page by page by any means. But I do know that the Act requires borrowers certify that the loan is necessary due to the uncertainty of current economic conditions. So what that means, I don't know if we know all those details yet, but there is some form of certification that you have to provide that says, I need this just in case to retain my workforce and maintain payroll. I have a client right now who asked me the exact same question and said, it looks to me like I should go ahead and get the loan just in case, because I don't know. I'm okay right now, but what if, my client base does start to dry up if this continues on for several weeks in the future. And so at this point, it does look like, there is not a downside, because you can certainly certify that you may be at risk if you feel like you are in that position that, clients could go away. They may not be going away today, but, it is a pretty uncertain time for most businesses.
Yeah, it seems like another situation could be where someone has a business debt and it's honestly an employee issue, but they need to make sure they have funds coming to pay that. And they could make a trade-off of saying, hey, I'll pay my debt instead of paying, worrying about the, instead of balancing off the obligations for salaries and stuff. So, some further clarification on that would be helpful.
Yes, and I've reached out to our loan group on this precise issue, and as I can pass that on to RJ as they clarify it further. I believe they're going to be doing a webinar later in the week, and so I can also pass that on to RJ to pass on to all of you, because I would highly recommend that you jump on that because it really would benefit you to kind of get the nitty-gritty on this particular law from them, because I think there are some requirements. And when they say that you have to certify, what does that mean? Are they going to audit every single company for where that particular dollar went, and whether it was paid for payroll purposes or otherwise? That seems like a hard thing to do, but it's worth learning more about.
Very good points.
Thank you.
Yeah, thank you. With that, again, I know, sorry guys, without the raise hand, but who wants to, any other questions out there, I'm sure.
It'd be good to know how many out there are, how big your workforce generally is. And certainly if several of you have, multiple employees and you're considering a layoff or a furlough or otherwise, just kind of what your situations are.
I'll ask a question. I mean, I think just in the interest of what is going on, Mary Kathryn, if we have, W-2 employees, just as an example, anybody on the call, I assume a lot of the people that are on the call have less than 50 employees. What is the process of, the actual layoff or the furlough? Do they need to go to a website, or, what is, what is the bare bones minimum that needs to get started, and then therefore also how do what's the next best thing then for us to relay to our employees or 1099 workers as well?
So there is no particular process when you're going through, when you're talking about a small company and you're going through a layoff or a furlough. Really just the big points to keep in mind, which some of these are just not legal points at all, but it's just how do you want to go about doing it? In this current climate, there's been a lot of chatter about how do I do it when I'm not in person with anyone. And this may seem like a very basic thing, but we've had to tell people, make sure you're not doing this on email. Get on a Zoom call or get on a phone call at a minimum if you do need to make these tough decisions, and just think about how you want this to play out down the line. And one of a business expert that we sometimes look to and work with, he recently spoke on this topic and made comments that you want to think of it as, what if your grown child was calling you to explain what happened to them when they got furloughed or laid off, and how would they describe the process? And would you as a parent say, well, that's a horrible experience, but it sounds like they really handled it the right way. And kind of thinking through your process in that respect, which again is not legal advice, but it's just thinking through how you're going to do this to provide the softest landing you can, and create the culture and climate that you're trying to keep in this really difficult time. But as far as legal considerations, when you're talking about a furlough, I mentioned, the biggest thing if you're furloughing and not laying somebody off is just making sure they know that they really cannot work during this time period. Because I think people think when they're furloughed, I'm not working because the company needs to save on, dollars, but I still expect to get my job back. So, I'm going to still reply to these emails and handle a few things. You do not want that to happen. And you need to, on the company side, make sure that does not happen. The other big question is, do they get unemployment if they're furloughed versus laid off? And in both scenarios, yes. This is very state specific, and it's state by state as far as how much unemployment you can get. But almost every state is dealing with, these massive requests, overloading their systems for unemployment. And many states have taken action and issued emergency rules to expand unemployment options, make sure unemployment is available quicker, those kinds of things. So you just, you're not required to let them know that they can apply for unemployment, but that's something that is usually what employers want to do. They want to provide some information to their workforce. And then just give them a way to stay updated on the company. If you're thinking about, just trying to get through the next couple months, and then you want to be back up and running, or that's your hope or plan, or, your projections say that, that's likely to happen. You just want to be able to communicate with your workforce down the line and give them some sense of, when you will be checking back in and giving them an update on that. So the difference between furloughing and laying off is really just whether you think this is short-term or whether you think this is long-term. But that's again, a business decision. And really, there's not a legal question in there as far as what to do.
Yeah, great point. I'm going to ask one more question, and then we'll kind of open it up to the floor. I think for a lot of business owners, maybe even on the call, we're thinking of different ways to share work, or even potential like pay cuts rather than, layoffs or furloughs. Is that legal? What's the process? Also, what's a way to pitch it to your employees, right? I mean, no one wants layoffs. No one wants to be on unemployment. So, what advice do you have for everyone there?
Well, I just had a client send something to me to review, and they had prepared this memo to their staff. And they're a company that has just under 50 employees, and they are doing a company-wide salary reduction for their exempt employees. And they had it set up in tiers with the employees making the most, getting the biggest cut, and it went down from there. But they just did a really nice presentation with a memo kind of explaining to their workforce, we don't want to be doing this, but, we've taken, considerable time and effort to really look at our projections and to see where we are financially. And, this is, sort of just a big overview of this is what we're seeing. They weren't opening up their financials to the whole workforce, but they were saying, generally speaking, we know we're going to see some losses here, and we expect them to continue through, this particular date. And then they presented some questions to their workforce just with a set of FAQs saying, how do these salary reductions work? Will we get the money back? How long do we expect this to last? And they just did a long list of FAQs that I thought was very helpful, being thorough and trying to cover, all the big questions they knew would probably be coming from their workforce, and then indicated that each individual will get a personalized, memo essentially from the company stating what their new salary would be. I thought that was a pretty nice way to handle that issue.
Did you advise them on that as to what that should look like, putting that together, or was that something that their internal comms team put together and then you, did a once over on it, or what would you potentially suggest for everybody on the call that's considering, those options or some sort of a template?
We did not draft the memo or the FAQs. We were not advising on the specifics of the financials. The internal business advisors were working together to determine just how much they needed to reduce the salaries. And then where I came in was just a review of that memo and a review of those FAQs to make sure there were no legal issues. And I asked some questions, certainly with respect to, how deep these cuts were going to hit certain employees, so that they didn't dip below, necessary levels for exempt status. Certainly you don't want to dip below minimum wage. That was not really their issue, but that was more my role. And they did internally, they sort of did the drafting and made it sound good.
Yeah.
For lack of a better way to say it.
Good. Thank you. Let's open it up to the audience. Any business owners out there, investors, questions on employment labor law?
Hey, RJ, this is Steve Walton. I know we have a lot of employers on the call. So I just wanted to maybe ask Mary Kathryn a question. For the employees that have been furloughed or laid off and are W-2s and have company leaders that are still reaching out to them, phone calls, maybe them answering emails, things like that would be considered a form of work. What are the penalties that the companies could face if they're not compliant with the expectations being put forth?
Well, essentially, it's a bigger concern when you're furloughing an employee, because they're still getting health benefits. They're technically, they're still acting as an employee, but they're just not currently working. And that's more of an issue because their email is usually still set up. So they're still getting contacted by customers potentially or clients. When you're laying somebody off, typically everything is cut off at that point. You're no longer on company email. You're no longer an employee. You're no longer having contact with customers and clients. And the internal side of the business will have redirected, if it's an account manager or, somebody who does deal with the customer client population, they're going to find somebody else who's going to take that over in a situation where somebody's been laid off. But the furlough situation is a little bit more gray, because you may not want to make those big changes because you're hoping or planning that this is temporary. And so it gets a little dicier because people still they still have their email, they still want to respond to things, they still want to, do a little work here and there. And that's where your liability goes up, because you can get hit with, FLSA violation at that point that you haven't paid for hours worked. And an exempt employee's example, you have to pay for a full week of salary for any day that individual has worked. So for an hourly employee, you pay for the hours worked. But for an exempt employee, you have to pay that full week's salary if they're working at all that week. So you just run the risk of having a claim filed down the line that, wait a minute, I did do work and I wasn't paid for it.
Thank you so much. I think that's helpful for everybody to keep in mind that has employees that might be furloughed right now.
Mary Kathryn, I just got a question from one of the audience members. If you have to lay someone off, what process do you recommend to get the company property back, like a computer, maybe an office key, things that they might have?
Well, generally speaking, especially if you're a smaller company, you have a good relationship with your workforce. So if it's not a situation where you have an agreement, a written employment agreement where it says, you have to return all company property, or you don't, you could have employment policies where that's specific in your policies and they've signed off on those policies, and you can just provide a reminder that, at time of termination, you are to return all the property based on X policy or based on whatever agreement you have with that employee. But generally speaking, you're just going to ask for those things. If it's a situation where you're not providing severance, you don't have that leverage of saying, until we receive all company property, you won't receive a severance. Of course, if you are paying a severance, that's another way to handle that severance is not provided until that has been done. We have also seen some employers who feel like they cannot give severance, but they can give a computer away. So we've had some employers say, well, you know what, let's just let them keep it because we're not in a position to pay any severance, and this is a benefit that we could provide to them. But otherwise, you're in the position of asking for them to do the right thing, and you can certainly go after them if they don't, because it is company property. But unless you feel like that person is just a bad employee and they're going to run away with the computer or whatever item it is that company property, you're probably in an okay place to just say, we're really sorry this is happening, and we'll provide you the shipping items that you need to get that back to us, especially now that you can't have anybody come in and meet with you and bring that with them. You will have to trust that they'll ship that back to you.
I think I might have heard a question. If not, I've got one more that came in. Anything else from the floor? Okay, I think one of the things that we all want to be optimistic through this time, and if we do have to consider layoffs or furloughs, when this thing comes to an end, what is the process of bringing people back? I mean, what steps do we need to take as employers? Are there any legal implications or issues that we should be aware of? I'm just thinking through like the motions and logistics of actually hiring a W-2 versus a 1099. Is it that all over again? And what advice would you give or counsel the audience here?
Well, I think, when we start to bring people back, it's going to be the same process. It is going to be the same process all over again. If it's a situation where they're not furloughed, they've been laid off and you're rehiring everyone. The biggest question that we're getting right now on that front is just, can we bring people back as 1099s instead of W-2s? Because we're going to be, in a situation where we don't feel like we have cash flow. So it'd be better to just work on a contract basis with some of these individuals, but we don't want to lose them entirely. You don't really want to do that, because if you had hired somebody as a W-2 and they're an essential part of the function of your business, and then all of a sudden they become a 1099, that's a pretty big red flag for the IRS and other agencies that they're not supposed to be a 1099. So you want to be pretty careful about, I have a client right now who's going through that exact situation where they have had to lay off a significant portion of their workforce, and they have a few individuals that they'd like to bring on just on a contractor basis to do some sales work. But the problem is they had those exact same people doing that particular type of work as W-2s before the coronavirus hit. So it wasn't a situation where they didn't really have that role before and they're creating that role just on a contract basis. They had that in-house role in existence. So that's going to show up as both a W-2 and a 1099 for that individual in the same year, which is not ideal. So if you want to do that kind of thing, you want to talk that through with an attorney and make sure you're, being very careful about how you do it and what you're doing specifically and why. So that's probably the biggest, I suppose, red flag to just keep in mind when you're trying to figure out how to, gather your workforce back up or keep some in this, difficult time.
Very true. Thank you for that. And I think we're right on schedule, guys. We do have time for a couple more questions if anybody's out there before we wrap up. And again, this will be a recorded session, so you can go back and listen to it anytime. Any other questions out there?
Yeah, this is Carl Rauscher again. And again, this is a question like my other one, kind of more on the fringes of this. So I think there's a certain cutoff date in the beginning where this applies. I'm just kind of wondering, let's say if a company is in a situation where, because of business reasons, they let people go in January, early February, kind of pre this event. But, how far back could, they'd like to bring those people back. They just didn't have the money, and this loan could make that happen. I mean, what is the time period of when people who've been let go kicks in?
So say that again. What is the time period for?
Well, let's say there's a scenario where in January, employees were let go because of business reasons, and they didn't want to do that because of other pressures on the business. Can this situation be used as an opportunity to bring money in to pay those employees so they can be around for the next several months?
So your thought is to bring them back to work using one of these SBA loans to hire back a portion of your workforce. Am I understanding that correct?
Yes.
Okay. Well, I think, arguably, again, this is without getting into the nuances of, how much you have to certify to get this money, but that could arguably work, except for the fact that this is a short-term payroll, coverage of your payroll. So if you're talking about an 8-week period of payroll, and we don't know what's going to happen in 8 weeks with coronavirus and whether everything's still going to be completely shut down, worse, better, it sounds like a fairly short-term fix. So, I'm not sure if it works as well in that particular scenario that you just described, where you're trying to ramp your workforce back up, unless you think your business is really going to somehow ramp back up by that time. You may just be covering yourself for a shorter period of time and then, in a similar position again in a few months.
Yeah, no, I
That would be
understand.
my initial thought.
Yeah, that's it. I'm just trying to get a little more insight on some of the edges of this. Thank you.
Yeah.
Great, thanks, Carl. Any other questions from the audience? Man, you guys are an easy group. All right, well, great session today. A couple things before we conclude. I want to say thank you very much to Mary Kathryn, our presenter today on labor and employment law. Also, our counsel for this session, who's Polsinelli. We are going to have several other of these starting tomorrow and Wednesday again on contracts, fundraising through these difficult times. We will send you a follow-up information link with a survey, and then also a link to the live stream that we had recorded today as well. And I think it's very important. Mary Kathryn, how can people contact you if they have further questions about this, their business, employees, anything? I'm also going to share my screen now and show you Mary Kathryn's contact info, but feel free to let us know what's the best way to get a hold of you.
I think obviously we can send out my contact information and anyone can email or call with questions. Certainly happy to dive in deeper on any of these particular issues. And I think it might also be helpful, just based on Carl's questions with respect to this SBA loan and the nuances of that, because I do think that's probably relevant to many of you. I will make sure that RJ has the plan for that, the individuals in my law firm who really are diving into that particular law and what the provisions state and all of those details, Carl, that you probably would like to better understand. I believe, like I said, that they're doing a webinar this week on that issue. So RJ, if you are willing to share that with the group, that might make the most sense. So you can refer back to that as well.
Absolutely. So here's your contact information. Do you want to give your email or what's, again, I'll send this all out, guys, but if you have any urgent pressing questions, hopefully I'll get it out today, but if not, Mary Kathryn, do you want to give your info?
Yeah, so it is on, you can, Google this, obviously it's on the Polsinelli webpage and the email is right in there as well, but it's mkcurry@polsinelli.com. So it's easy enough to find it on the website if you don't have it written down. And again, you can reach out with any questions that you have.
Awesome. Well, thank you again, Mary Kathryn. Thank you, Polsinelli, and thank you all for joining today. What I will say just before we conclude, the surveys mean a lot to us, guys. So if you will just take a few minutes, not even 30 seconds, and tell us what you thought of today, what we could do better, and what future sessions we can implement, we'd greatly appreciate it. We're all in this together. Thank you guys for being a part of it, and have a great rest of your week. See ya.
All right, thank you.
Thank you.